Good morning, everybody, and welcome to today's launch of the publication, See You in Court, the Effectiveness of Climate Litigation. My name is Ruben Henriksson, and I'm the director of the climate program here at Inför, the green and liberal think tank. If you want to follow Inför on Twitter, you can find us there, and please feel free to share your thoughts on today's seminar. And remember to hashtag for us in your tweets or to tag for us in your tweets there as well. And I'm going to start right away by saying if you want to order the book, you can find it online on Inför's webpage, and you can also download it there for free. My colleague Malin will be following the YouTube comments section. So if you have any questions or comments, feel free to share them in the comment sections. And at the end of this hour, we will have some time for questions from the audience. So please ask your questions there. So this is the book that we're discussing today, See You in Court, the Effectiveness of Climate Litigation. And it's a publication that we've done in cooperation with the European Public Forum, ELF. And it's written by Kristina Forsbacka, who is here with me today, as you can see, at a safe distance. With us today, we also have Cos van den Berg, who is a lawyer in the Netherlands and who worked with the organization Agenda in their case against the state of the Netherlands, which is one of the cases you can read about in the book. And he's an expert on climate litigations and will give us his insights on the Agenda case. We also have Åsa Romson with us, who is an environmental law doctor, an expert at the IVL Swedish Environmental Research Institute, and a former minister for the climate and environment here in Sweden. Finally, we also have Oskar Alarik, who is the chief legal advisor at the Swedish Society for Nature Conservation, and he will also give us his view on the publication. But first, I'm going to give the floor to Dr. Miloš Hudun, who is the second vice president of the ELF board and a member of the Liberal International Climate Justice Committee. So over to you, Miloš.
Hi, thank you so much. I would like to say this very short word of welcome on behalf of the European Liberal Forum Board of Directors and of the European Liberal Forum in general. So just for those of you who do not know ELF is a think tank and a foundation of the ALDE party. So this is a liberal think tank and liberal foundation that coordinates work or gathers about 50 liberal organizations from all over Europe. And climate change has been one of the topics we've been working about for last years. But this book that we are presenting today is very special. I mean, it's extremely interesting, of course, but it's very special because of its novelty, because it's connected to the climate change, of course, but the scope and the angle of climate litigation is something that we've never done, and I've read the publication with great interest, and I would like to congratulate you for this publication and for this event. And the topic we're going to discuss today is extremely also interesting and timely and topical. Also for myself, also for the Liberal International Climate Justice Committee. As we see, there is more and more litigation all over the world. Right now, so far, there's been right around 1,500 cases filed, most of them in the US. But if we look in our field, in Europe, Europe is one of the most important places also if it comes to climate litigation, and the European Union as such as an entity plays an extremely important role. And if we're talking about this topic from our liberal perspective, of course, the important factor is the human rights, something very close to all liberal hearts. But I would like to comment on one other aspect, which is the science. The climate litigation is very much connected with and very much accelerated by advancement in science, because science is used in the court. And science shows us that climate change, we can still do a lot if it comes to prevention of climate change. And even those extreme weather conditions, very often they can be foreseen and prevented. They're preventable by the science. And I find this argument and this connection between the litigation and science very liberal, because this is connected so much with this liberal optimistic point of view. Optimistic, not in a way that we everything is okay and everything will be all right, but optimistic in a way that the liberal people believe that there is a lot we can still do, and we need to take action connected to science, action connected to the courts, to change the situation for the better of us, for the better of the people of Europe and all over the world, and for our own human rights and for the rights of the future generations. So one more time, I would like to say thank you so much for this event and for the publication. And I wish us all a very fruitful discussion. Thank you.
Thank you so very much, Milos, for those kind words. And I fully agree with you that the novelty of this publication is really what makes it so very interesting. Thank you very much to Elf as well for the help with this publication. Okay, so we're going to talk now about what is this publication about. Well, Kristina, who is better to explain that than you, the author of the publication? So we're going to have a short presentation with PowerPoints. So over to you, Kristina.
Thank you, Ruben, and thank you, Elf, for providing this opportunity to me. I have written about 4 strategic climate cases. I have chosen 4 European cases which are different from each other to illustrate how climate litigation is moving forward in a positive way, as you said, Milos. As Milos said, there are 1,500 cases at the moment, ongoing cases, the majority of which are in the United States. The objectives are, let's see.
Let's see if it's on. I'm just going to have a quick look.
Yes.
Yes, okay, we got it there.
The objectives are, one is to force governments to take action against climate change and to increase their mitigation efforts. Then you also have climate cases against carbon majors and corporates. You have climate litigation against financial institutions and investors. And the litigation is based on human rights, as we have the Agenda case, fiduciary duty, corporate responsibility, and damages. The 4 cases, that I have chosen, du kanske kan ta fram. Thank you. Is of course the Agenda case, the Agenda Foundation against the state of the Netherlands, which is a class action suit and which is the foremost landmark climate case you have, which is referred to worldwide. Then I'm going to speak about the Heathrow case, where you have an NGO which sued the Secretary of State for Transport on a public policy matter. I have chosen 2 cases against corporations. One is the NGO Client Earth, which sued INEA SA, and then you have an individual citizen, a Peruvian farmer, which sued the German utility RWE. And these are each interesting from different perspectives. The Agenda case, of course, you have the Dutch Supreme Court establishing that the state must reduce its emissions by 25% by 2020 compared to 1990 levels. This case shows that you can challenge the state ambition based on human rights. And this is truly new. It also states that the courts have an obligation to protect legally protect their citizens against the effects of climate change. And this also concerns protection against the government. And the legal grounds for the Agenda case are Articles 2 and 8 of the European Convention on Human Rights. It's the protection of the right to life and the right to respect for private and family life. The court notes that climate change is a real and immediate risk. And I would here also like to refer to the climate science, as Milos so correctly said. The climate science is a very important basis for all these cases. The protection that the courts shall provide also includes the society or the population as a whole. It's not based just on individuals. You can also claim that the society as a whole is suffering from climate change. You can say that the court decision shows a continuous evolution in the norms and principles in the international agreements. And you have to take the new scientific insights and generally accepted standards into account. Another important issue in the Agenda case is the separation of powers. Normally, you would say that it has been the duty of the politicians or the international organizations to take care of climate policy, and the courts have not been supposed to interfere. There's a line between the political domain and the judiciary. However, Urgenda found that the courts have a right and also an obligation to step in and to provide legal protection when the politicians do not do that. And as Mila said also, finally, climate science is really the basis and important for this. There is an urgent need to reduce emissions, and this is considered to be common ground in the Urgenda case. There is a genuine threat from climate change, and all states must do their parts. You cannot put the blame on anybody else. Each state has an obligation to act. As the European Convention on Human Rights applies in all European countries, all the national courts can refer to the president, the Urgenda president. This is really important. However, what you can say is that in the Urgenda case, the Supreme Court did not ask for an advisory opinion from the European Court of Human Rights. That would have been interesting. They had this possibility, but both the state and Urgenda wanted a quick decision. They wanted a decision before the end of 2019 because the mitigation had to take place in 2020. So the court said that decided that the matter was sufficiently clear and issued their decision. You can note notably though, the president of the European Court of Human Rights refers to the Urgenda case in his speech in January this year and says that this is an evidence of that the European Convention can provide a response to the problems of our time without amendments. So he has accepted the decision, you can say. The second decision, which is very different from Urgenda, is the Heathrow case and concerns a third runway on Heathrow, which was very disputed. The decision is a judicial review of a planning decision under national law. So this is a formal issue and it's decided under national law. So it doesn't have the same implication as the Urgenda case, but it's still of interest. The Court of Appeal found in the case that the airport's national policy statement, the ANPS, which is a document that is to be provided when you have a big infrastructure project as the third runway in Heathrow, they found that this was not produced lawfully. And the reason was that the Paris Agreement was not taken into account by the Secretary of Transport. The Secretary of Transport explicitly said that he had not considered the Paris Agreement. First of all, the limits of the court's role was emphasized. The court said that this is just a formal decision and explained that it's not for the court to decide whether there should be a third runway or Heathrow, or whether Heathrow should be expanded or how. What the court said is that the Paris Agreement constitutes government policy. And this means that as under UK national planning law, government policy has to be taken into account when providing the ANPS. The decision was not provided lawfully. The question was whether the court should grant a remedy, and in order for the court to grant a remedy, there was a need that to know that there might have been another decision had the Paris Agreement been considered, and the court said that it was not excluded that the decision could have been different. But under all circumstances, the matter was of exceptional public interest, which meant they were obliged to provide a remedy. And this is an interesting conclusion from the court, that the issue was of exceptional public interest. This is, as I said, a decision by a national court, and it has also been appealed, so we don't know what the final decision will be. I will also briefly touch upon two cases against corporations. Client Earth was the NGO was also a shareholder in Enea, which is a Polish utility owned by the Polish state. And the decision here concerned the construction of a 1 gigawatt coal-fired power plant in Ostroleka. which was to be jointly sponsored by Enea and Energa, and both Polish utilities, state-owned utilities. Client Earth claimed as a shareholder that the decision was harmful to the shareholders and that the board of directors had broken their fiduciary duty. They were planning to take a decision which could mean that the power plant would become a stranded asset. And that was a transition risk. The regional court decided in Client Earth's favor and ruled the decision invalid to construct the plant. And Enea and Energa decided to pull funding from the project. And this may be, of course, partly due to the transition risks and the economical risks which are emerging. And finally, a case which I find very interesting is Lea versus RWE. Lea is a Peruvian farmer. And he claimed that RWE, the huge German utility, should be liable for 0.47% of the cost of flood protections that were needed in his hometown due to the melting of a glacier caused by climate change. And 0.47% is the equivalent portion of RWE's historic responsibility for total emissions. And this is also, here you also have a science-based investigation backing this up. There is a report where you can see carbon majors, how much they have contributed to climate change. And the Court of Appeal found, they admitted the case, which is extraordinary. They found that the climate damage can give rise to corporate liability. They have appointed experts for the case to determine whether there is a threat to Lea's property. And they are now expecting to collect evidence and are planning a visit to Peru to have a look at the site. I would like to conclude, as I said initially, of course, Urgenda shows that climate litigation can push governments to take action, but it also has impact on the market and on businesses. You have, of course, the risk for damages, like in the Lea case. You have the risk of investing in a non-profitable plant that could become a stranded asset, as you have in the Enea case. This creates pressure on corporations to change their financial decisions to invest in fossil fuel plants. It's a transition risk. You risk to be sitting with stranded assets. You also have increasingly a reputational risk, risk as regards the value of the company. And this is something that companies increasingly are taking into account. And then you have, of course, you have litigation related to inadequate disclosure of climate change impact and risk exposure. So to conclude, I would like to say that this is the risk for litigation is something that the corporations, not only governments, but corporations increasingly need to take into account. But it is, of course, only one part of a climate policy. You have climate policy awareness and financial climate finance regulation coming up as well. Thank you very much.
Thank you so much for that presentation, Kristina. Could I follow up with one quick question that I was thinking about? How come that a Peruvian farmer sued a German utility company? Is there any reason that RWE was chosen?
I don't know the background to why they chose RWE, but it might have to do, but that it's easier to have litigation in Germany, perhaps. Yeah. This is just my speculation, but it might be easier to have litigation in a European country than perhaps in the US or somewhere.
Yeah. So. Okay. Thank you so much. Now we're going to go to Kos van den Berg, who, as I previously mentioned, worked on the Urgenda case and is an expert at climate litigation. So, Kos, could you please give us some insights from what it's like working on such a case and what consequences you think the case could have in the future?
Well, first of all, yes, I'd love to. Thank you very much for inviting me here. And I had the privilege to already read what Kristina wrote, and I want to make her my biggest compliments because I think you did very well in explaining the Urgenda case in your book. And I've read a lot of comments on the Urgenda case, but yours is really one of the best. So that's for starters. Yes, well, there's so much to tell, so I have to be very limited, and I hope I'll get within the stay within the time frame. First of all, you must understand what the situation was when we started the agenda case. In the Netherlands, we had no national climate change law. We had no national economy-wide greenhouse gas reduction targets. We had not a national economy-wide consistent reduction policy, emission reduction policy. The Dutch policy was basically, well, we'll do what the EU tells us to do, but we'll try to negotiate ourselves to the smallest possible effort. And that's what we'll do, and we'll do nothing more on top of that. Well, it was also very well known to the Dutch government that the EU itself admitted that it was not doing enough. So that was where we stood. And well, first we asked the government, are you willing to put in more effort to emission reductions? And then the state wrote us and they said, well, we do agree with you that climate change is a very urgent problem. And we do agree with you that the world must do more, must absolutely do more than it is currently doing. But we, the Netherlands, don't want to be a front runner. Well, that was quite a thing to say, I think, because I'll try to show you here. The pink dot in the end were the Netherlands. So I think we were not exactly a front runner. So that was why Agenda decided to start proceedings, and our goal was we wanted a national economy-wide reduction target that would be, well, probably not sufficient, but much better than it was. We asked for 40% reduction target, but we were well aware from the beginning that that would probably be too ambitious. So we said, well, but it must be, it should be 40% really, but 25% will be the absolute minimum which is necessary. That's what we asked, and that's what we finally got as well. And just for some perspective and some context, you must realize that 25% emission reductions in 2020 does not make the Netherlands a frontrunner, because the EU on average will realize an emission reduction of 27% in 2020. So even if the Dutch government complies with the agenda decision, the Netherlands still won't be a frontrunner. We will even then be below the EU average. So this is something to put in perspective. Well, how did we set out how did we, what were the legal foundations of our case? Well, first of all, we had two legal grounds. First was tort law, because in the Netherlands there's a national law that says that unlawful is any act or omission that is in breach of the written law or in breach of the unwritten standards of care that is due in our society. And hazardous negligence is unlawful, because then you don't take the care that is due in society. And the second ground that we were basing our case on were the human rights, Article 2 and Article 8, the right to life and the right to family life. There's a lot of case law from the European Court of Human Rights that says, well, any danger and disturbance of your family life, also physical dangers, are part of the protection right that you have. So environmental problems can affect your right to family life. And so we said, well, climate change is an environmental factor. So that falls within the scope of Article 8 of EVRM. And we were helped along the way, because when we started this procedure in 2013, The Paris Agreement was not there yet, but in the Paris Agreement that was in 2015, there was very clear in the preamble of the Paris Agreement, it says that climate change is a threat to human rights, to the enjoyment of human rights. So I think this helped to shift because the district court decided that we were entitled to, that we were right. We won the case, but we won the case on tort law, not on human rights. And then there was that was in 2015. And then in December 2015, the Paris Agreement was concluded. And then the Court of Appeal in The Hague in 2018 decided, yes, Urgenda was right, but not just on tort law. We don't have to decide whether or not the decision of the district court to base it on tort law is right or not, because we think that it can be based on the human rights as well, and those are much stronger. So we think that's the basis for our decision. And that's what the Supreme Court decided to agree with. Well, what does this right to life of Article 2 of the Human Rights Charter and Article 8, what do they say? Well, they say that these are very fundamental rights of citizens, and the state must do everything within its power to protect those rights of the people who are within its territory. And what the state does must be effective and must be adequate, and unless it puts a disproportionate burden on the state. The state is not obliged to do the impossible thing, but it must. But if it's not disproportionate and it is adequate and effective, then the state has an obligation, because, of course, the right to life is a very, very fundamental right, and that the same holds true for the right to family life. So. There is, I'm going to try to explain this by some, like this. So there's the base, one basis was tort law, the other basis was human rights, but those are both written laws. So there is a legal duty, a legal obligation written in law. And the tort law says that the written obligation is you have to apply due care, the care that is due in society, and the human rights say you must take adequate protection. But the problem is, what is the standard of care, due care? What does it mean, due care? What is due? Is 10% due? Is 30% due? And the same holds true for the human right. You can say, yes, adequate, okay, but now we have a discussion, what is adequate in the circumstances, in these circumstances? So there is a legal obligation, there is a duty of care in written law, which means that the judge must apply them. But then we still have a discussion, yes, okay, there is a duty of care, but what is the standard of care? And 25% is not written in any law at all. But then the judge starts to looking from, can I find an objective standard which is widely accepted, which is commonly accepted? And then we pointed the court to the fact that in the COP decision of 2010, that's the Cancun decision, that there was this 25-40% was mentioned for the first time. The COP decision, just to be clear, there are about 159 countries that have concluded the United Nations Framework Convention on Climate Change, the UNFCCC. And every year there's an annual meeting and they make new decisions, how they're going to execute and how they're going to refine the obligations from the treaty. And this annual meeting is called the Conference of Parties, and they make decisions there. So the Conference of Parties is COP, and they make decisions. Those are called the COP decisions. And they made this decision in Cancun that really the global temperature should stay below 2 degrees. And in order to reach that, the rich, wealthy countries, the Annex I countries, like Sweden, like the Netherlands, really should reduce their emissions with 25, in the range within 25 or 40% in 2020, ultimately, compared to the emission levels of 1990. And such a COP decision is not legally binding by itself. But that doesn't mean it is irrelevant. Because the decision in Cancun is widely referred to as the Cancun Agreement. It was an agreement by all those nations. And it was not, this agreement was not put into a treaty, but it was a decision. And this decision was repeated in every COP decision in any later year, 2011, 12, 13, up to 2015. And even after the Paris Agreement in 2015, the COP decision said, we should put in more effort, we should enhance our efforts, because if we won't do more, if we won't do better than this, the targets of the Paris Agreement will not be achievable already before the Paris Agreement entries into force. So that's what the Dutch judges said. Well, there seems to be an international political consensus that maybe not it shall be 25% at least, but a consensus that it should be at least 25% and probably 40%. And this is not just the COP decision, because this 25-40% range was also adopted by the European Union and is at the heart of the European climate change policy. And also the Dutch government referred to these COP decisions, and until 2011, the Dutch government even said, well, considering that we have very high emissions and considering we are very wealthy and we have the technology, well, the Netherlands should at least realize an emission reduction of 30%, because anything less would not be credible. So that's how we also pointed to all this to the court, and then the court said, well, there seems to be a generally accepted consensus that this is what the Netherlands should do, 25% at least. Probably, preferably 40%, but 25% seems to be accepted as the absolute minimum. So this is a consensus, and it's not written down in law, but it is not irrelevant. And the Supreme Court said, well, this consensus is actually the common ground in the European Union. This is what all European nations think that their group must achieve. So, and then the state started complying and said, yes, but these COP decisions are not legally binding. So what are you doing now? You are treating these COP decisions as if they are legally binding, but they are not. No, we said, and that's what the courts also followed this. We said, no, it means there is a standard you should comply with, unless you can explain why it is not, this standard is not applicable for the Netherlands. Does it put a disproportionate burden on the Netherlands? No. Is it impossible? No. Did the science change? No. Well, and that's when the court said, well, yes, it's probably not written down in law, but it is a relevant factor to decide whether or not what the obligations for the Dutch government was. And that is basically how the decision was made. It was, and this is where I'd like to make a link, if I've got time still left.
You can finish up with the final link here.
Okay, well, this is what, so it's not that the judges applied this 25%, but they said, well, there is a consensus, a common ground that it should be 25%, and you should comply or explain. And that is what more or less seems to have happened in the Heathrow case as well, that the judge said, well, there is this climate change targets that you should reach, but you must explain how this decision on Heathrow fits in within your frame. And it also happened in an Irish case that Jenny was involved with, that the Irish court said, well, I can see what your long-term goals are, but what you on the short term are doing is very different. Do you have a credible plan how these two can be linked with each other? And the Dutch and the Irish government was not able to do so. So then the Irish court said, well, you must do it all over again. So I think this is more or less pointing to the way that the courts will go. And it's also that has also to do with the balance between the judiciary and the political domain, that the judiciary is asking the government to the political domain, this is your call, but you must show me and make plausible that what you are doing is fitting and consistent with the long-term goal, because the long-term goal, the dangers and risks are so exceptional that you must take them in account and must be on a credible course to prevent those risks. And I think that's basically the role of the judiciary.
Thank you very much, Kos, for those passionate words about this. It's super interesting, and I could listen for a long while, but we have several speakers to get to as well. But I just want to point out that I think it's really, really interesting, the view of the Paris Agreement or the decisions by the Conference of Parties as setting some kind of standards for the judiciary to look at when they're making their decision. I think that's a really interesting view on the whole climate agreement within the UN. So thank you so much, Kos. We're going to get back to you, but first we're going to go to Åsa Romson, who has a doctor's degree in law and has previously worked as the Minister for Climate and the Environment here in Sweden. And we are very, very interested to get your thoughts on the book and on the phenomenon of climate litigation and what your thoughts are. Let's see if we can get Åsa on the screen.
I think I'm on, right?
There you are.
Yes.
Hi, Åsa.
Hi, and thank you very much for bringing this event, and thank you, Kristina, for writing this book. I also had the privilege to see it in advance, and I think it's really interesting topic that it's not only a few that are starting discussing it and starting acting on it. It's really happening things, and I want to reflect on maybe two things, and also I'm astonished about, really nice to be able to, in this real event, listen to you, Kos, about the Agenda case, as we have been watching it a lot. I still there is these reflections on the connections, and as you made, Ruben, the connection. I don't think anybody really, or I don't. It doesn't come to my mind that anybody reminded me of what the consequences in legal terms for this kind of case litigation actions in courts, which is a kind of a concrete action. You need to have a case. You need to have there's a lot. That's a lot very long link from an international agreement as the Paris Agreement. And when I was in Paris, because that was at the time of being a minister, and this agreement was really historic, and we saw it very clear. But still, I think this angle, that it also actually would be a direct influence on climate litigation. I don't think that was at people's mind at the moment, because we were still aware of this was another, it was just good that there was another decision for all countries actually taking responsibility, but it was still an international agreement, which are very soft in a legal terms, and there has been a lot of debate about the soft and hardness of Paris. But I want to reflect on two things here, and one thing is that we could definitely see that why is climate litigation happening in courts? Is, in a way, you could be optimistic and say this is because people are taking their rights, and they are seeing that, they want to push actors who's not been thinking enough, governments, business, to push them to act, and you could need the court to make that push. It could be quite hard work. There might be other pushes, in media or communication actions or lobbyists or whatever, but of course, court cases is something real interesting too. But I mean, we don't see that there is good cases, and you described them very well, Kristina, but there is also a very hard way. There is a lot of cases that are failures, actually. We know that. And that could be because we are still, I mean, the environmental lawyers and the people going to court are still kind of developing the tools and so on. But I was wondering if it's also a failure of the legislators, because of course this is, for me, a sign that the politicians and the legislators they're not on the toes yet. I mean, signing the Paris Agreement could also be like, okay, we do that and now we've done it. And you don't go home and say, okay, wow, we need to, I mean, change the way of how this society works, because we are still dependent on fossil fuels. I mean, where is the legislation of the phase out of fossil emissions? Because as long as you don't have a legislation of the phase out, and you might turn in having some of the emitters or some of the governments behind the emitters, because a lot of them are state owned and so on, going to court, that is I mean, it might not be the best way. It's definitely not economically and feasible for the society, a good way. It might not even be the best justice, because you will not be able to balance how transition is made for workers, for different parts of society and so on. So I think, in a way, climate litigation today is a sign of a failure of the legislators, not taking their responsibility, not reading the Paris Agreement and enforcing the real laws, the laws that actually goes to individuals. And so that's what we see, not only in some of the European countries, which should be more on their toes. We've been having the European discussions and so on. So that is, I think. And the other is, of course, we should mention here what is one of the elephants in the room, and that is what the climate litigation has certain new features that makes it maybe more difficult than previous environmental litigation. We have the historical lines, which are very long, while the emission and then the damage. And we also, of course, have the south-north connections where it could be a very long transponder. And this Peruvian farmer case against the German energy company is of course interesting in the way of connecting these tools. So I think what also has to be reflected on is that the climate litigation might be even more interesting in the perspective of how do remedies for climate damage or climate change damage. Actually, we probably need also to see the new tools, both in case law, built by case law, and built by legislation when it comes to remedies for climate change, especially in the days of huge weather events with connections to climate. I think that, and that is of course a cornerstone for the law community and for the case law, because such situation of damage it's based on I mean, we have long tradition of conflicting solving such conflicts in courts. So I reckon that in that area of tort law and of cases with how to remedy damages will also be a very big area. But back again, that also would need some more legislators to come to sense. And maybe some of these cases can also do that for a change. So congratulations to an interesting topic for the book.
Thank you so much, Åsa. Do you have any comments, Kristina, on what Åsa just said?
Just very, very shortly. I agree with you that the situation with a lot of climate litigation is, of course, a failure of the legislators. But I would still like to take an optimistic view and hope that the litigation can put pressure on companies and governments, and they pose a real threat that if you don't do what you're supposed to do, perhaps everybody will start acting more in line with the Paris Agreement. So that is, and I think, you know, when you look at the European New Green Deal, I think that there is hope that the legislators will take this more seriously. And I also think you see, for example, BlackRock, the CEO, Larry Fink of BlackRock, the world's largest asset manager, is going out and expressing that they're going to divest from coal. So I see positive signs, but I agree with you, it shouldn't be litigation that solves the climate issue. I fully agree.
Thank you very much. We're going to go to Oscar now. Oscar Alarik, who is the Chief Legal Advisor at the Swedish Society for Nature Conservation, and get his thoughts on the publication as well. And perhaps we'll find some questions there for us to answer. And after that, we're going to have time for a few questions from the audience as well that we're going to try to bring up. So let's see if we can get Oscar on the screen together with us.
Hello, do you see me now?
Now we see you, Oscar. Very
nice to be here, Ruben, and thank you very much. I'm, as you said, the legal counsel for Swedish Society for Nature Conservation. We are an environmental organization in Sweden with 230,000 members in about 270 local branches all over the country. We're just out of a major legal climate conflict here in Sweden. It's been known as the Primraf case. And it was about an immensely large new expansion of a refinery on the west coast that you might have heard about. Initially, they wanted to double the emissions of carbon emissions, and that would have meant that the plant would have been Sweden's single biggest emitter of carbon dioxide. And that case, we took that to court for 2 years ago, almost precisely. And just a few weeks ago, we came to a stop when actually the company backed out of the case. So we are very happy for this, really. They did that with, they said that the economy was in another situation now. And that is probably a correct interpretation of where fossil fuels are now. The risk for stranded assets is considerably higher than for just a few years ago. I'm also very happy about this excellent report, Kristina. You really have the finger on the pulse of an important development in climate law and climate policy right now. And it's an extremely interesting and comprehensive report. And I might be the wrong person to say so, but I think it's very readable also for non-lawyers, although some finer points might get lost if you're not a legal eye. And I'm honored to be here with no less the former environmental minister, and but I'm equally starstruck, of course, of having Koos van den Berg here. I'm a great fan of your work, and the Society has followed the Uganda case for several years closely. That said, I strongly agree on what has been said about climate legislation being a response to the national and international institutions' failures in some sense. The report's observations here is quite to the point too. We still lack climate laws that safeguard us from the path out to a climate future we all fear. And I cannot emphasize enough the importance of what is said about the rule of law. I think everyone can agree on that climate legislation will never be the only way to climate mitigation, but it must be a central part of it if we're going to succeed. Law is the only thing that can manage thousands of millions of decisions that are necessary, and law is essential to safeguarding against the day-to-day political decisions that have a tendency to favor short-term solutions. Law is important there. But law is also important to put responsibility where it should be. where the power is. And that is how we achieve accountability too. Something that we haven't spoken much about but was important in the Uganda case, and several of the other cases, has been the issue of separation of powers, the separation between government, parliament, and the judiciary. And in the Uganda case, this was one of the critical issues. Had the courts the right to decide about the nation's climate objectives, or did that belong to the political dominion? Interesting enough, this was also a hot issue in the Primraf case. But there the criticism comes from the exact opposite direction. The right-wing parties mainly argued that the government was overstepping its boundaries when the government decided to take over the trial of Primraf, as you might remember. And that is also very interesting. I'd say finally that one conclusion when it comes to climate litigation is that there will always be someone who says that you are barking up the wrong tree. Another conclusion is that the responsibility for climate often is left in the cracks that separate the powers. And that is very comfortable for a lot of us. It's no one really has the responsibility. And there might be one thing that is very important with climate litigation. Climate litigation can change that. It can bringing climate cases to court can clarify responsibility and put it where it belongs, not in the cracks, but where the power is.
Thank you very much, Oskar. That's really interesting to hear from you. And Kristina, do you have any comments?
Well, just a very short comment. I think you bring up a very important point when you talk about the separation of powers and who has the responsibility. Where does the responsibility lie? I think that's something that needs to be discussed further.
Yeah, thank you. So in the last few minutes, we're going to have some questions from the audience. So we're hoping we can bring the whole panel back. And I have some questions that Malin has sent me that I'm going to ask. And I would just like to start with one question that you might all have the same answer to. We'll see. But as we see the increase in climate litigations, should we or do you have any fear of a backlash? I mean, countries might be more apprehensive about signing an international agreement if they're fear that they're going to be dragged into court if they don't follow it. Do we see it as a risk, or what is your view on the potential backlash of climate litigations? Is there anyone who would like to take the word?
Well, I don't think the backlash would be for states not to sign agreements. There are so many other hinder at the table where states are joining forces and agreeing. So I don't think that those kinds of litigations, because of course I think rather it might encourage more states to actually see that these agreements matters, because they are interested in seeing that other states are doing their share. So I think for the large part of states that think that the Paris Agreement is the absolute minimum, and that is just a framework for the real action, they want to see more accountability from especially from states with a lot of muscles like the Netherlands and Sweden and the US and Brazil and so on. So I don't think that would be the problem. The problem is probably more on the legal side, that legal court cases are very heavy, and there will be a lot of them that are not as successful, and some will be some economic burden for small groups and so on. So I think that might need more emphasis.
Do we have anyone else who would like to comment on that? Or else
yes. I think that even if there is a slight backlash or cases lost, I think the function of clarifying who is actually not been doing their job might still be there, even if some of the cases are lost. So that function is still there, really. We can never say that the climate litigation will be the big solution, mainly because it's very hard to litigate against all forms of climate emissions. I mean, car companies, all authorities that are dragging their feet. It's not especially the organizations, the environmental organizations, doesn't have that resources to do that job. But it has a place to play, I think.
Can I add something? I agree with Asa as well, but in the end of it, I think even if there's no treaty, if there's a backlash and states are becoming hesitant to enter into treaties, as science becomes even more clearer that we are heading for a disaster because of our emissions, even without treaties, the citizens are going to tell their governments, you must act now. You must, with or without a treaty. These dangers are from such a magnitude, are so exceptional, that citizens are entitled to be protected by the governments, even without a treaty telling them so. The treaty is an expression of something that all people feel that must be done, and we must do it together. So that's...
Thank you very much. We have all of these legal expertise in one digital meeting room. So we have a question from the audience, which is a bit off topic perhaps, but I thought I would ask you anyways. There's been a push for the idea of legislation against ecocide, or ecocide as a crime. And I'm sure you've heard of it. It's basically criminalizing destroying large environmental parts of the world and stuff like that. And do you see, do you have any thoughts about the future of ecocide? Do you think it will become illegal at some point or criminalized? Do you have any thoughts on the subject?
Well, I've been thinking about it. It's the problem is, one of the problems is that the law is mostly by far about people and not about nature in itself. And when the law says something about nature, it's mostly about preserving nature, the functioning of nature for mankind. So it's not because we are going to protect a tree because it's a tree, no, we're going to protect a tree because humans need trees. So it's all very anthropocentric. And so the concept of ecocide is in itself, I think, a bit puts a strain on the concept of legal obligations. And there's also the problem, who is going to be the advocate of the ecosystems, because they cannot speak for themselves. And isn't it the government or is it someone else? Which makes it quite hard to say how this should be approached. I like the concept of preserving nature, but you don't have to call it ecocide, I think.
Okay. Thank you very much, Kos. It's almost 11 o'clock. An hour goes by quickly. So I would like to ask Kristina, do you have any final words before we end the seminar?
No, I would just like to thank the panelists for participating. It's been very interesting to listening to you, and I'm really pleased that you did attend.
Yes.
And thank you for reading the book.
Thank you for reading the book. I would also like to extend my gratitude to all of the panelists, to Kos van den Berg for participating, Oskar Alarik and Åsa Romsen. It's been great having you here. Finally, I would also like to give a big thank you to all of the people who has viewed the seminar online. If you are interested, you can of course order the book online, and I hope the seminar really has brought you that have made you interested. Kos, I know you have to leave for for court. He's actually at the court of appeal. Bye. But we're going to end the seminar there. So thank you very much, everybody. Stay safe, stay healthy, and we'll see you at the next seminar. Goodbye.